of Everything Compliance. Today we have the quartet of Jonathan Armstrong, Karen Woody, Jonathan Marks, and Tom Fox sitting in as a panelist. So we had lots to talk about. Some of us are going to talk about the Monaco Memo, but Mr. Armstrong, you have some small amount of news about Facebook from across the pond. What do you got for us today?
Yeah, I do. Thanks, Tom. Um, I think some people are saying this is a revolutionary change to antitrust enforcement and GDPR enforcement. I'm not sure it's that revolutionary for reasons I'll describe, but it relates to Facebook, the artist formerly known as Facebook, now known as Meta, and its privacy policies and its compliance with GDPR, and whether that can found effectively an antitrust action. And apologies, by the way, for my voice. I'm recovering from COVID, but I'm non-infectious if you're sat on the other side of the airwaves. And effectively, what happened here is the um, Bundeskartellamt, the German antitrust regulator, said that Facebook slash Meta had not complied with GDPR in the way in which it had obtained data and amalgamated data from users, which it then obviously resold to enrich advertising. And they said that it was relevant that Facebook was in a dominant market position and that effectively its a breaking of GDPR without effective sanction was itself an antitrust violation. And Facebook decided, surprisingly, that they didn't like that argument from the German antitrust regulator. And they ran along to court in Dusseldorf and effectively said that the reasoning from the Bundeskartellamt was wrong as a matter of EU law. Now, what happens in the EU regime, if somebody raises the EU law flag, then generally that gets referred to the ECJ for an opinion to determine, well, the answer to the EU law question, if you like, so to a central European court. And they have a two-stage process. First of all, where they have an attorney general's opinion, and the AG will say how he thinks the court should decide. And then, secondly, it goes to the court proper, who can agree with the AG or they can depart from what he says. In the majority of cases, they agree with the AG, but in some privacy cases, like the first Schrems case, for example, the court didn't decide exactly on exactly the same lines as the AG's opinion. And here, though, we have a senior AG, AG Rantos, who's the Greek AG in the court. He's a former senior constitutional court judge in Greece. I won't pretend to have read all of the judgment, but it does seem very reasoned, and I think it's one where there's a fair likelihood that the court will follow the AG's ruling. So, why do I think it isn't a surprise? Well, I had a discussion about this as a sort of theoretical construct in 2016. We've talked before about Max Schrems on our podcast, and I spoke with him, and we had a public debate about where would antitrust regulation go post GDPR. And I think the theory that we both eventually agreed on is that there's something of a sort of triangular shaped regulatory model when it comes to regulating big tech in Europe. And the top of that triangle might be privacy regulators, might be data protection authorities regulating how they handle data. But the two bases of the triangle might be antitrust regulators looking exactly at the same topics that we're talking about here, abuse of dominant position. You could, by the way, take other big tech organizations and argue that they're monopolists. It's it's been an acceleration of time, hasn't it, technology? So if you look at people like Andrew Carnegie, for him to go from market entrant to dominance, I don't know the exact numbers, but let's say that was 20 years in terms of US steel. Maybe it's the same length of time with railroads. But organizations like Uber can go from market entrant to market dominant in 18 months, 2 years. And I think that gives more challenges to antitrust regulators as a result. So I think they're the one corner of the triangle. And then I think the other corner of the triangle is fair trading regulators, so the equivalent of the US FTC. And I think they're likely to have much more of a role in terms of fairness. If Facebook are dominant and their terms and conditions aren't at equilibrium with consumers, are fair trade regulators going to step up to the plate as well? But the other interesting thing, I think, where this all becomes really quite complicated indeed, is the different regimes have different ways of handling regulation within the EU. So, as a very general rule, under the antitrust regime, there's a central coordination office in Brussels, and they can direct cross-border investigations from groups of regulators. And in this case, obviously, the German regulator has been active in big tech. But the privacy regulator for Facebook is Ireland. And it's been perceived that Ireland are sort of dragging their heels. And some say that that's why the Bundeskartellamt wanted to act more, because the chances of Ireland doing anything quickly were slim. Now, of course, that's changed again in the last week or so, with Ireland bringing another case against Meta, and we're told that more on the way with more significant fines. But there is this whole confusion, really, as to where those 3 points on the triangle fit together, particularly because the EU structures deal with those 3 points in different ways. And does this have wider ramifications for other businesses that aren't Facebook? Well, I'm pretty sure it does, really. I think a lot of organizations will be fearful of GDPR violations, but the perception from many boards of directors, for example, is that GDPR isn't enforced. Now, that perception is untrue. As we sit here today, we're just under 2 billion euros worth of fines. I think the number today is 1.86, something like that. So GDPR is being enforced. But obviously, antitrust regulators have other powers as well, to reject deals, for example. And we have seen privacy regulators try and get antitrust regulators to block deals in the past. DoubleClick, the acquisition of DoubleClick by Google, would be one example. So I think if you're involved in any personal data at all, then I think this case does really heighten the risk of antitrust regulators and privacy regulators getting involved and almost fighting between them as to who can be the toughest kid in the schoolyard. Now, obviously, there are some caveats to this judgment. The AG has tried to set out almost a framework for conflict. So, saying, for example, that a data protection authorities' investigations and findings would have to be considered by an antitrust regulator, and saying that where relevant, if an antitrust regulator wants to take the lead, then that antitrust regulator should consult with the data protection regulator. So you're trying to avoid some of these conflicts. There are checks and balances that are separate but similar in the antitrust regime from the European Commission, and in the privacy regime from the European Data Protection Board. And the other thing that the AG is saying in this opinion is that the data protection elements of the antitrust investigation should be incidental and not dominant. So an antitrust regulator can't suddenly decide, hey, I'd much rather be a data protection regulator this morning. I'm going to put a different hat on and do a different bit of regulation. The focus of an antitrust regulator still has to be antitrust. But despite those caveats, I think if the AG's opinion is adopted by the court, I think there are going to be some really interesting consequences, not just for Facebook. Obviously, Facebook, it is material. There's the potential for significant antitrust fines in addition to the 4% of global revenue for data protection fines. But I think it will go down the food chain as well, because I think if you give antitrust regulators more tools, then as sure as eggs are eggs, they'll try and use them.
So, Jonathan, how would this play out literally across the countries of the EU and the United Kingdom? Would each regulator perhaps bring their own action? Would it go back to Ireland for consideration, or does Germany now have a dog in this hunt?
Yeah, I think that's definitely right. That there are potential conflicts. There's a perception that some data protection regulators are weak on regulating, and so the perception is leveled at Luxembourg and Ireland. Ironically now, the regulators with the biggest GDPR fines. But the perception, certainly from some countries like Germany, is that Ireland is weak on regulation. So there's this potential conflict, I think, here of Ireland almost wanting to protect particularly US corporations that use Ireland as their HQ, and German regulators possibly going on the attack. And we've seen that from other countries as well. We've seen investigations into US corporations that HQ through Ireland from regulators in the Netherlands, in France, in Spain, with them saying almost we don't have to respect the GDPR rules when the DPA, that's your lead regulator, does nothing and sits on her hands. So, I think there is potentially some significant conflict here. And potentially, of course, we know that some at a European Commission level are also unhappy with the way in which it is perceived that enforcement is unequal against from different countries in the EU. So there's potentially an involvement from the Commission, who, as I say, almost run the antitrust regime, to get more involved, to address some of the concerns that they've had about unequal privacy regulation.
Do you think Max Schrems has an interest in this? Just, I don't
Yeah,
want to say philosophical interest, but actually an interest in his agenda. Does this matter really touch on the things he's talked about?
yeah, I mean, for sure it does. Yeah, I mean, as I say, that's the discussion that we had back in 2016. I know that his group have issued a public statement on the case this morning. So absolutely, it's on his agenda. Is he front and center in this particular campaign? I don't think so. I think the Bundeskartellgesamt have handled this one, off their own bat, if you like. But is he is he an interested bystander, with ringside seats to watch the battle? I'm pretty sure he is.
I think that this is something that we'll be watching and perhaps visiting on again.
Yeah, I think so.
All right. Across the pond to our professorial panelist, Karen Woody.
All right. I'm going to pivot from Facebook and we're going to get into this about Deputy Attorney General Lisa Monaco's speech and the accompanying memo that adds to the DOJ guidance regarding corporate compliance programs, really, and just this idea of how the DOJ will assess corporate criminal enforcement policies. There's some shift, as we can see from this memo. And I think you actually learn a little more about this even from the speech and the text of the speech as well. So for those who aren't aware, there obviously are various procedures, not necessarily binding law, but the procedures that the DOJ follows when they are assessing what penalty to mete out or how to handle companies when faced with, particularly here, FCPA or other potential corporate criminal violations. So we're in this space of, all right, how well is our compliance program doing? Have you self-disclosed? These are the topics that these policies address. And as we've seen with this new policy, the guidance from the DOJ is that they are not going to pull any punches. And this is the next step in what I think has been an increasing temperature increase from the DOJ in a number of different areas, but all of it surrounding this idea of we want to hold individuals accountable. That is sort of priority one, anyone who's breaking the law, but specifically send the individuals in, send the executives in who are making these decisions that lead to potential FCPA violations. Also in this memo is this idea of what it looks like to comply and to have voluntarily self-disclosed, such that you might get some cooperation credit from the agency. And so the one I wanted to focus on, and I know there are others on this call who will get into some of the other items that are included in this speech and this memorandum, including things like monitorship, executive comp plan, things like that. But I want to talk about this concept of the timeliness of disclosures. And apologies in advance that this is going to veer into my rant, maybe, because I have some opinions about this one. And just honestly, I have opinions about this in general. We've seen this steady sort of inching of the agency toward pressuring companies to voluntarily self-disclose. We saw that years ago with the pilot program, this idea of this inherent potential carrot of a declination if you come in hat in hand and tell us what went wrong and tell us maybe that you fixed it. This, I think, step that we saw this last week, again, this came out on September 15th, so not too long ago. I think this next step is crossing the line, in my opinion. I mean, the demand of timeliness is really such that, the language of the memo says to receive full cooperation credit, corporations must produce on a timely basis, and the word timely is underlined, all relevant non-privileged facts and evidence about individual misconduct that prosecutors have the opportunity to effectively investigate and seek criminal charges against culpable individuals. So again, the timeliness component of this is housed under the individual investigations, individual accountability section, which is interesting. But the reason I think this is problematic is if we can just zoom out to the 30,000 foot level, we are talking about the Department of Justice. This is an agency that is prosecuting people for criminal violations. And as we all recall from our time in law school or otherwise, just watching Law and Order, that requires that the government to prove beyond a reasonable doubt the facts of their case. Compliance is kind of this sort of gentleman's agreement that we're not going to make you do that. We'll sort of split the work. We'll have you guys come in and have us, you tell me what it is you guys did wrong if I'm the DOJ prosecutor, and then I'll decide whether or not there's enough to make my case. That's not how it's even supposed to go from Jump Street. Let's start there. The government hasn't proven the case. They're taking the work of, at this point, the defendant to say what went wrong. So the idea that we are now demanding that gets sped up, and the idea of speediness comes out more in the speech than in the memo. I mean, underlined in our speech is we need to do more and move faster. In individual prosecution, speed is of the essence. That's a standalone paragraph, that one sentence in this speech. So this idea that, pressure, move faster so we can figure out who we want to prosecute criminally for these potential FCPA violations, anti-bribery, problems regarding bribery abroad, things like that. So again, I have a problem with, again, we aren't in a phase where the government is mounting a case that they are proving beyond a reasonable doubt that you have violated the law, because there are criminal penalties that attach. So that's the first sort of structural issue that compliance is always kind of dancing around. This idea of like, well, we're not really there. Let's just make this easier for everyone and get a better resolution because we came in and did some of your job for you. We did an internal investigation. Here's what we found. We fired these sort of rogue employees that maybe were causing the headache for everyone. So let's just move forward. The timeliness thing seems to suggest that the DOJ wants to step in before that point. So before maybe even a full internal investigation has been done by the defense counsel, and basically hand over the people who the DOJ will then individually prosecute. So to me, this suggests sort of a violation of the process in the sense that, the defense counsel here, this isn't this hunky-dory, we're all, grasping hands with the DOJ and singing Kumbaya, making sure this all gets remediated. Sure, that's kind of what we keep talking about, but at the end of the day, this is an adversarial process. And the role of the attorneys is to advocate for their clients. And so I think the idea that we want to essentially deputize corporate counsel to turn over individuals immediately without maybe even having the time to suss out what's really going on, how deep does this go? These investigations take months, if not years. Everyone at the Department of Justice likely knows that because they've either been on the defense side before or have been in these FCPA matters before. They know that this takes a lot of time. And so the idea that we are now demanding of companies we're kind of narking out the C-suite to see who is in charge or who is culpable for this, to me feels like, and it's impugning on an attorney-client privilege, on the role of defense counsel to be strategic about when they voluntarily self-disclose. There's a lot in her speech about, taking the time and gaming when you'd self-disclose or not. And I would just push back on that and say, of course, that's what's happening. We are advocates for our clients, and there is going to be some real discussion about what we disclose, when we disclose, if we don't have all of the facts. I think this, this speediness is a problem with the structure of what they're doing, and I worry that this might result in people not taking the cooperation credit and saying, we cannot, we'll run that risk of not cooperating because the alternative could be very damning. And like I said, with criminal penalties attached, these are people going to jail with some of these individual prosecutions. And I think it's risky. So it's a rant. My apologies. Oh, I will also say, because Matt's not here and he was going to talk about compliance officer certification. When I last had to give a talk about that, the idea that this comes at the same time, to me, I know when I was having this conversation with Lauren Koopman about it, she was like, no, those things are totally separate. I'm like, but it feels ironic to me that we're going after individuals as hard as we can, and you're now making compliance officers certify this. We really are supposed to read those two siloed as separate. It seems to me like the compliance officers should be getting nervous, and everyone should be getting nervous about this. And so I do wonder if they've gone too far, and it might have a backlash of people not taking the risk of self-disclosure given this. So anyway, that's my rant. I'll pause there because I'm sure there are people who want to jump in and push back at my uber defense lawyer stance on this one.
Mr. Armstrong, do you have a question or comment for Ms. Woody?
I do think you're right about the self-reporting. I think there's a really difficult balance here. I'm still halfway through, as Tom knows, the ENRC judgment, which is this huge tome. I think I'm up to page 214. So wish me luck. I've still got to get to page 386 before I can give you any formal opinion on it. But one of the things that case tells us in the public domain, and I've certainly seen it in the private domain, is it's really challenging to get a corporation to self-report. And in some respects, and any corporation sort of needs some sort of certainty as to what the process will look like. And I'm not saying they need an easy ride, and I'm not saying prosecutors should give them an easy ride. But if we look at the fact that on both sides of the pond, there have been no super stellar victories for prosecutors, and if when you self-report you're expected to do more, then that equilibrium gets really challenging. You're going to get many senior management in corporations, I think, are going to think, well, hang on, the chances of us getting caught are less than they were, let's say, 10 years ago. And the things we're going to have to deliver to get a deal are more than they were 10 years ago. And when both things are moving, then your worry is that it's, prosecutors closing the door to self-reporting. I think that's over dramatic.
Mr. Marks, do you have a question or comment for Karen?
Yes. And it kind of talks about what she was talking about with regards to self-reporting and the like. But I am taking this all in and kind of thinking about this a little bit differently. And I think it all depends on what kind of matter it is. That's first thing. First of all, second thing is, with regards to self-reporting, my bigger fear when doing an investigation and whether to voluntarily disclose or not disclose, or self-report or not self-report, consciously or unconsciously, is what do they know or what don't I know that they know? And are they going to come for me? And if they come for me and I don't go to them, then what happens? I don't want the troops showing up on my doorsteps with gold badges, and then all of a sudden I go, oh, darn, we should have done something. So, in the world that we're living in with more transparency, and what I'm talking about here is I'm talking about the financial institutions monitoring transactions more closely now with suspicious activity reports and, all types of CTRs and things like that. I'm wondering where that information is now going, how they're sifting through it, considering that they're getting a lot better at that. And if they realize that something bad is going on, and that something bad is going on, I know that, Jonathan, you were talking about sort of this, kind of what do we do? But, I think those things need to come into play. In addition, I also think that was something that was very cleverly included in the memo there, and it is it builds off the Yates memo, obviously. But I think something that's very clever in the memo there is, they started talking about, sort of past bad behavior by individual and by the company. And, I know they put sort of these markers on there from a timeline perspective, but if there's not organizational justice being carried out in the organization, and they're letting this behavior perpetuate in any regard, and there's either some direct or indirect relationship between the individuals that were supposed to be accountable for this or not, I think that throws a different monkey wrench into the scenario here as to whether the organization and the individuals are going to get. Obviously, the individuals are probably going to be more targeted, but from a corporate perspective, it certainly plays a different role there. And I'm really interested in your thoughts on that because, there are a lot of investigations that are not disclosed. And I'm wondering, if the DOJ goes in there and starts ripping through board minutes and finds out that there were investigations and things that never manifested themselves to a higher level, are they going to look at those things as well? Because I don't think it's what has made a DPA or an NPA or whatever. I think they're going to start to look at the full landscape. When we talk about the compliance program, I think the compliance program includes, evaluation of those bad behaviors. Was there a root cause done? I don't think there's any coincidence with the fact that this came out with, CCO certifications. I also don't think there's any coincidence that they're placing greater emphasis on the compliance program now, specifically in light of the data that came out with the U.S. federal sentencing guidelines saying that 89% of organizations didn't have, I don't know whether they used adequate or whatever, compliance programs that got basically pinned, for those particular set of circumstances. So I'm a conspiracy theorist by nature. I thought when Sarbanes-Oxley came out, it was sort of a shot across the bow, building on the FCPA from an internal controls perspective. and then as that sort of manifested itself and we've gotten where we are, now all of a sudden Gensler comes out in the beginning of the year and talks about maybe revamping SOX. Now you sort of have these things going on, and then you have this whole thing now with tying in compliance. And now, okay, we're going back to accountability again because, Sally, I think, did a good job in outlining that in her memo. But you got to remember there were prior memos too that talked about individual accountability. You also have what we've all talked about, which are these Caremark cases, where we talk about board oversight, and individuals responsible. So I think, there's a confluence of toxic sewage coming together. And, I think it's about time that these organizations woke up. And, if I'm sitting in the DOJ right now, I think they're in a pretty good spot because I think they have better data. I think there's been enough warning. I think there's been enough news out there where people should be watching this, understanding it, synthesizing it, and saying to themselves in their own board meetings, hey, is this something that we should take a look at from our organization or not? So, it's all been out, it's all been laid out there. And so I'm just kind of curious as to your comments there based on my little diatribe.
Okay. I have a couple comments just off the bat on this one. First is, I do agree. I think what we'll see from this is again, just my maybe crystal ball. I think the corollary sort of consequence here is an unbelievable power given to whistleblowers. Because to your point, if the government doesn't know, well, I'm not maybe thinking I'm going to go in if I'm going to get in trouble for not having gone in before. If you're already on your back foot as a corporate counsel, thinking about, oh gosh, do we self-disclose? Are we too late? Are we not? I mean, the fact that the whistleblowers are able to blow the whole thing open, and even maybe with bounty program and attendant money for that, I think whistleblowers now have a lot of power after this. The other thought I had about what you were saying, and I agree that there are 1,000 other consequences. Obviously, board liability on this, I think through Caremark might still be tricky because I think most people are hopefully aware of this and there's someone on the board sort of thinking about this. But I think your thought about the fact that they're really doubling down on corporate recidivism here. And this is something Matt Kelly talked about a while ago, but I think is an interesting point, which is, find me a company that hasn't maybe had some run-in with the DOJ or something like this. And so what incentivizes that company to turn around and self-disclose now? I mean, it's one of those things like you get one ding, you're not going to turn, like you're going to hide it maybe the second time because already going in, we're going to get a recidivism like, treble damage or something, however they're going to play that out. And so I do think this idea that like the irony here might be that you are pushing back from this, like I say, collegial vibe that we're all going to be in this together and have a compliance program and work together and figure this out. You might have some pushback of companies being like, you know what? Nope. Come knock on my door and prove it because I'm done playing ball. Like, I don't know. I don't know that we'll ever actually see that. I never saw that in the 10 years I was practicing, even though I always sort of hope someone would be like, can you make the case? I don't know if they always can. But this, I feel like, is making the stakes so much higher that we might see some of that, especially for a company that would be already dinged as a recidivist. I don't know what their incentive is.
Yeah, and I'll just make one last comment. I go back to, Tom's sort of mantra, 10, 12 years ago with document. But more importantly, I think it goes back to even further back to that. I forget what year it was, but the Seaboard memo talks about when you recognize something that's going wrong, you better start to fix it at that point in time. You can't wait. I forget the 4 factors off the top of my head, but policing, I think, is one. I can't remember the other 3. But anyway, long story short is if I walk in and I had an issue before and I remediated and that same thing came back in a different flavor, that's one thing. But my whole thing, even with when Sarbanes-Oxley came out and people say that they remediated controls, and, we've all had this conversation collectively amongst ourselves. And, even, if you don't have a remediation plan and you don't document that remediation plan and you're not able to show someone exactly what you did, including organizational justice with regards to disciplining employees and what that discipline looks like, including in the fact incentive compensation, which means it may be clawback, it may be some other type of thing for some individual. I think you're in you're in a deeper level of toxicity than you are if you don't. And I think, again, when you look at all of this and you kind of bundle it all together, it's like, look, we started this in 77. We came out with something in 2022, in 2002. You implemented it in 2004. We had Dodd-Frank. We have all these other things along the way. We have these guidance memos that were issued. We've given you enough runway and enough warning that you need to have your proverbial stuff together. And if you don't, we're gonna crush you. And I think they're in a really, really good spot now. So yes, you can play the game where, hi, we're here, and guess what? And you could say, well, guess what? It's kind of like you go back to, what's the movie? Clear and Present Danger. You don't have one of these, do you, Jack? Kind of a get out of jail free card. But your get out of jail free card, in my mind, in all of this, is showing that you have a good governance process in place, showing that you have a robust risk management program in place that's not a set it and forget it exercise, showing your compliance program. But more importantly, in all of that, is when you do remediation or you do change things, where is that documented? And at the end of this, is there some type of organizational justice put forth on these individuals or these bad actors? And if you can't show that at a minimum, I think you don't have much protection there. You just don't.
Yeah, I hear that. My point is simply that when that carrot becomes too hard to attain, it's not doing the job. And so you might just say, all right, show me the stick then. That was all I meant. But I think you're right. Like people should know this. I mean, the stick isn't maybe an inappropriate solution to your point. Like, you should have known this. You guys should have all seen this coming. So anyway, I've monopolized too much of your time. I'm passing back to Tom.
No, I think it's a great conversation.
It is. And I'm going to pick up on it when I have a few remarks. But before we get to that, Mr. Marks, what's on your mind?
Well, Tom, you asked me to talk about investigations, so we'll meander our way into the Monaco Memo again and investigations, which sort of layers itself in the memo accordingly. But again, the whole investigation process, I think, really comes under fire now, and that really starts when what are these investigation triggers? And I know, Karen, you talked about the whistleblower. Do you have a whistleblower program, and how is that being worked, and is it consistent, and do you have a process related to that? When you're doing triage of an allegation, is that consistent? How are you? What are you looking at when it comes to these particular allegations that are coming through? Are you treating them the same way? And what's the timeline for all of this as well? Are you acting on these things quickly? So I set up investigations. I have a 5-step approach, 5 pillars that make up the investigation puzzle. 1 is investigation triggers. 2 is allegation triage. 3 is planning. 4 is investigations. And the 5 is the remediation process, which we'll get into in a second. But I think that if the DOJ comes in and they start looking, and you don't have something like this where you actually go through and address all these specific things, including, should it be an internal investigation versus an independent investigation? How is this treated? Once you get to the senior level and senior level is implicated or a board member is implicated, you got to get it out of the hands of the internal, and you have to do an independent investigation. People don't understand that even today. When I lecture, Karen, not in the classroom but outside at this point, and I talk about the difference between an independent and an internal investigation, and you'll hear my rant later about this because Tom was there to witness it live and in charge, but last week. But a lot of people don't know the difference between an internal and independent investigation. They think they're the same. They're not. They're absolutely not, and they need to be treated accordingly. But again, some of this goes back to sort of your own organizational awareness. So internal audit can't carry an investigation all the way through when there's senior management and there's board members involved. They just can't, because I think that a lot of things come into play there. 1 is independence, and 2 is their level of skill and capability. Some may have it, most of them don't. In my humble opinion, when you go through the investigation process, how are things treated? It talks about, we talk about actually in today's data, one of Jonathan's favorite topics, the other Jonathan, the better Jonathan on the call. We talk about devices and, are we looking at devices and communications, and do you have control over all those things? There's a whole bunch of things that keep coming out here. But again, those messages were sent based on things that happened in the past, right? And so I think they're just kind of rounding out some of the things that they're seeing that are more pervasive issues when they kind of bring out this stuff, in the memo, and then bad actors, how are we, these custodians are reviewing these custodians. What are we doing? How are we analyzing these things? Kind of what was done in the interview process, who was conducting the interviews. I think all of that is absolutely fair game if someone's going to look at your process and say, this was something that we believe that we can have some comfort on. And then at the end, from a remediation perspective, which is the sort of the fifth pillar, discipline. Are we disciplining these actors? How we conducted root cause? Are we using that feedback to enhance our risk assessment or fine tune or tweak our risk assessment process? Have we looked at that from a training perspective? Is our training right? Maybe it's not. Maybe we should be training on different things based on the feedback, and all these types of things. And so, I think that whole piece of this is something that really has not been discussed for a while. But I always ask, when I come in, do you have a fraud policy? Do you have an investigation policy? And the answer is usually no. They're not very difficult to put together, but it is, again, something I think that, if a regulatory body is going to come in, they're going to start poking around. Like I think they probably could start poking around. That's certainly something I'm asking for. It's certainly, and again, I'm going to start to say, it's not only great. Oh, well, here's my training. Well, what does that mean? How is this derived? I mean, they're really going to start to dig down. They're going to start to do their own root cause on your own process. And if you're not prepared for that, I think it raises the level of risk on your side. So, if you feel confident that your compliance program provides, what did they say? You have some reasonable assurance, or what was the phraseology that Polite used? Which really hasn't been defined yet. Provides some reasonable assurance or whatever for the overall organization. If you feel confident in that, you have these processes in place and you've done all these things, that's great. I think it's one of those things where, again, you might want to take some risk and maybe not disclose on some of these things. I don't know. But if you don't, and it's a game of what do they know, which we've all been in those discussions. What do you think they know? Is it possible that, this one went to the SEC or the DOJ? I don't know that I want to roll I'm not a gambler by nature, but I'm not so sure that I would even play that ticket at all. But I do think from an investigation perspective, I do think it's time that organizations go back and take a look and make sure that they have all the requisite pillars in there and that they're consistent and it's being applied appropriately across, across the board.
So, Jonathan, Karen raised a really interesting question, and it ties into something I wanted to raise with you. I've heard you talk and write about your 5-step process. I have put that into my compliance handbook as a guide to think through the process all the way from the initial report through triage, through elevating it within the corporation, to the investigation, to the remediation. And I've tried to communicate as strongly as I can. Each step has to be documented. And you set this process up before the report comes in so that you're not scrambling. And my question is now, do you, Jonathan Marks, the forensic investigator, or myself, Tom Fox, or Jonathan Armstrong, the lawyer involved, do we have to document our thought process, our attorney work product around when and how we disclose? Because if we, in consultation with our client, which is attorney-client privilege, make the decision to or not to self-disclose, will that then be evaluated? So number one, do I need to document my decision on whether or not to self-disclose, the timeliness of that self-disclosure? And then two, does any of that potentially violate the attorney-client privilege?
Well, I think you raise a good point, but the one thing I'll bring out here is we don't step in the shoes of management ever. So we don't make management decisions. it's not my job as a forensic investigator to determine the guilt or innocence of someone. That's up to the judge or the jury, and we clearly state that in our reports. But I think, whether to disclose or not to disclose, again, I think that's a management decision and a board decision. It's not a decision for the forensic investigators. I would throw caution out there that talks about, if you're going to issue some type of report, that you better have the proper disclaimers in there, because again, our investigations are facts and evidence based. That's it. If you're out there making, judgments about certain things or certain individuals and you include that in your report, I think that's a huge mistake. As a better practice today, we've also bifurcated our remediation suggestions into two separate documents. So we have our investigation document and then we have our remediation document. So they're in two separate documents. We do reference in our investigation report sometimes that we have made, suggestions for remediation to management and to the board, if appropriate, but we break those out. I think there's some chess game that has to be played here a little bit too, as you're going through and you're thinking about those things. You ask a great question or several questions with regards to this, but I think at the end of the day, if I'm part of those conversations, whether to disclose or not disclose, I'm purely there as a non-voting member, or if you will, to management, just providing my professional guidance and opinions and just trying to poke holes in whatever logic process that they come up with. But at the end of the day, that's not my decision. That's not my firm's decision. And it shouldn't, nowhere in anything that we write or put out there should we talk about that stuff. I think that's just opening the profession up for problems. And so that would be my thought there. I don't know if I hit on your question specifically, but if I didn't, maybe you can rephrase it and I can give you some more commentary.
Well, Karen, I was going to ask you, did that really encapsulate or encompass the attorney-client privilege waiver concerns you have, or is it something else?
No, I mean, I think, yeah, we're saying the same thing, which is, I think you set it up well, Tom, with this idea that is a strategy decision. And I can't, to me, I can't emphasize enough that, as corporate defense attorneys here, considering whether to self-disclose or not is a strategic, advocacy-laden decision that is defending your client, because no one's going to court. Like, this is when you're lawyering at this stage. I mean, I think, when I talk about this to students, it's this idea of like, the first call, when they have a call and they say, we need to look through your documents, the first fight you have is over what the number of terms are that you're going to run across terabytes of data. And that in itself is an advocacy effort to say, we're going to cut this down. We're going to try to keep them a little bit further away. Like, this isn't all just, like I say, full transparency, go along to get along kind of a thing. Like, I still back up to like, this is someone who is across the table from us, who is, has the ability to put the C-suite people in prison or, drastically change the nature of this company through criminal sanction. This isn't just and so to your point, Jonathan, I think you're right that they have a lot of power, and I find that unsettling. And so the idea that they would get, involved in maybe strategy decisions, discussions about voluntary disclosure, that I do think is in the realm of decision-making between an attorney and the client. So the answer is yes. I think you got to what we were discussing, but I think there's some major issues that this teases out.
Yeah, and I don't disagree at all. I think those are great points, but I think it goes back to, again, if you're sitting there and you're assessing your compliance program, or you're assessing, kind of where you are as an organization with regards to overall risk management, and that you have sort of a lumpy program that is not, where it probably should be for whatever reason, I think that really needs to be taken into consideration here, because if you're going to go up against someone who's sitting on the other end of the table, who's got endless resources, doesn't care how much money you spend, on this whole thing, they're just looking for some answers. That is a dangerous situation to be in. It just is. It's like any fight. If you're in a dispute with anyone, there's usually the person who has endless resources on the other side. They have a different strategy than you do. They may just want to ride you out until you break. I've seen the DOJ do that before, by the way. Wouldn't be the first time. So, but I agree with you.
That's a perfect segue to monitors.
It is a perfect segue to monitors. But if you're going to talk about monitors, why don't you talk about board advisors too? Because I also think that those could play a key role here.
But
So-
before we go into that, can I just say one thing? I think as an external lawyer, this becomes more problematical because you just have to be clear who your client is.
Yeah.
Are you doing an internal investigation, or are you doing an investigation for government as a proxy? And that is really problematical because obviously different people who you might interview people who are suspected of wrongdoing. You have to be transparent with them. How can you be transparent as an external lawyer if you don't really know who your client is? And we're in an era where we've talked about this on this podcast before. I guess I've not looked at this statistically, but prosecutors on both sides of the Atlantic are probably losing more cases against individuals than they're winning. And the reason, certainly, that they're losing in the main in the UK is because the prosecutors haven't followed proper process. We've had a director of the SFO who's having side meetings, the court has found, to the prejudice of individuals in criminal trials. You can't have that sort of underhand behavior and investigation by proxy and expect to get a subsequent prosecution through the jury. So this lack of clarity might also be self-defeating for the prosecutor. If the aim is, as a general rule in the US, we'll get the corporation to settle and we'll prosecute the individuals, then you're tethering your hands in those prosecutions against individuals if you don't structure the investigation in a proper and transparent way. And if individuals can claim that they've been duped or misled into giving evidence to support an internal investigation. So the whole thing is utterly fraught with difficulty. And just, Tom, to quickly answer the other question you asked about documentation and a lawyer's duty to document. As I said, I'm midway through the ENRC judgment, but there is an answer at least to that question. Paragraph 926 for the judgment geeks, which said that Mr. Gerard's failure to make notes where appropriate in an investigation is so basic and so legion here that there is no alternative but to find that he was committing a reckless breach of duty in this regard. So certainly the judge in the ENRC case is saying that there's an obligation on lawyers not only to make decisions, not only to walk clients through their decisions, but also to document those decisions and why they were made.
Well, Jonathan, as to your point about who is the client, federal district court judges have raised that same concern in some individual prosecutions. We have had one instance where a corporate officer was criminally charged with destruction of evidence, federally charged, I should say, with destruction of evidence in a federal criminal investigation, where she destroyed or allegedly ripped up documents on the way to the internal investigation by outside counsel. Now that indictment was later dropped, but we've got that on record. And I have wondered more than once out loud, if I'm outside counsel, I'm performing an internal investigation, do I have to now give a Miranda warning if I've self-disclosed and the information I develop could be sent to the Department of Justice for use in a criminal prosecution? Or I guess you would say under caution. But I think you're absolutely spot on. And those are unanswered questions that someone is going to have to deal with at some point. I wanted to talk about monitors. There are three parts to the Monaco Memo. And I once again say that quickly 3 times on monitors. Number one, a discussion about factors prosecutors should use in determining whether or not a monitor is appropriate. 2 is the selection of monitors, and 3 is the oversight of monitors. I want to focus on the first part, the factors that prosecutors have used, because I think it's a pretty significant change. And I'm going to purloin Karen's comments, see if I wrote them down correctly. the DOJ is not pulling its punches, and it's definitely increasing the temperature on what's going on. So under the prior administration, in the form of the Benchkowski memo, there were two questions that a prosecutor had to basically ask. At the time of resolution, had the company implemented an effective compliance program? And number two, had that program been tested? Those were brought forward during the first part of the Biden administration, but now that has significantly changed. So we've still got those two questions, which are questions 2 and 3, but the number one question, and I'm going to have to assume it's the most important because it's number one, much like I think about the First Amendment, is, did you self-disclose? Now, what does self-disclosure have to do with the need for a monitorship? I'm going to leave that question to the distinguished panel. But then it goes on to look at questions 2 and 3 deal with, have you put an effective compliance program in and have you tested it? But then it goes to the heart of the actions which led to the criminal conduct or the criminal conduct itself. Was it long lasting? Was it pervasive? Was it facilitated by senior management? Was there an exploitation of inadequate controls or the compliance system? Was there active participation of the compliance function or a failure of compliance personnel to respond to red flags? Did the company fail to take adequate investigative or remedial steps? Was the corporation's risk profile, had it changed and there was not an update in the risk profile? Or is the company under another type of regulatory scheme or in a regulated industry? Or is it involved in business sectors which are prone to high risk? So we've got the two former categories. Did you fix it? And did you test your fixing? But now we've got, did you self-disclose? How bad was the conduct? How high up did it go? Have you changed your structures? Have you done lots of things, or rather, it's conduct that occurred at the time of the incident? That seems to me to be inconsistent with what a monitor is there to do, which is to make sure you don't do it again, test what you have in place, and report on that testing. So we're looking at different things. The positive or the flip side to that list of factors to me, though, is that a company now knows what it needs to do. It needs to look at all of those, and it needs to evaluate its conduct in light of those factors. And I think that this could be a very enlightening list of factors that companies could use in a proactive manner to test their compliance program. So I think this goes to what Karen said as the heat's turned up. I really think the DOJ's put a lot more pressure on corporations. And I think that this section here both changes fairly dramatically the assessment of whether a monitorship is appropriate made by prosecutors, but also can give a list of factors and specific facts that companies need to look at on a proactive basis. So I'm going to take some questions if anybody has them or comments at this point. Karen, what do you have for us?
Yeah, I find that interesting too, that list, especially with what I was talking about, the timeliness of self-disclosure in the same breath as remediation, because I don't know that we can do those things the way they want those together. In fact, there's a line from her speech that, is shocking to me. Maybe I'm, again, overreacting to this, but the line says, if a cooperating company discovers hot documents or evidence, its first reaction should be to notify the prosecutors. In what universe would that happen? I just have this, if I'm sitting there with your contract attorneys finding hot docs, I'm going to turn them to the government first. Just as this. And so the idea that I just find it interesting that you are also required to have remediated, figure that out, maybe also fired those people or whatever. All these things can't happen at the same time. And they are important strategic adversarial decisions that I don't think they can have their cake and eat it too on these. Even just that list alone, as you point out, is impossible to do all at the same time. If self-disclosure and the timeliness of self-disclosure means immediate turning over of documents, I don't know how you then could have remediated. So I mean, even the factors don't all line up for me. So that's the end of my rant on that one.
Mr. Barks, you're on mute.
Yeah, I got to unmute myself, which is really easy to do. I almost think when she said that, and I read the same thing and shook my head, probably like you, I almost thought that she was coming from one vantage point was that a grand jury subpoena had already been issued and you didn't even know that it was coming, right? So, if you get a grand jury subpoena, again, I'm not a lawyer, but the lawyers can certainly comment here. But when you get a grand jury subpoena and you have to respond, generally there's some agreement as to kind of what information is being turned over, at that point. So I almost thought, if I put my investigator's hat on and I plug myself in a situation that I was in recently in dealing with a grand jury subpoena, it almost appeared to me that she was coming from that lens and that lens alone. I think she probably is kicking herself today that she actually said what she said, because I think to your point, there's probably other aspects of this, like when you're doing an internal investigation or an independent investigation, and there are a difference. I just made that clear. That when you come up with these hot docs, what do you do with them? Our first response is never, oh, let's call up, the SEC or the DOJ and let's say, hey, look, this is what we found. That's not what we're going to do. We're going to seek to understand the context of all those and perform a full, thorough, and appropriate investigation before we make any type of comment to anyone or assess whether we're going to disclose or not disclose. So I think she's probably kicking herself, but I read that and I said, I almost believe that she's thinking about if we come first and we issue a grand jury subpoena and you're replying back to us, this is what you should be doing. But she did not clarify that in her speech.
So next I'd like to turn to the question posed by our colleague, Barry Vitale. Thanks for joining us, Barry, and you pose an excellent question, which was, or is rather, in the context of corporate compliance programs and what information the Department of Justice communicated to us about those programs. They referenced the evaluation of corporate compliance programs document, or rather the original 2019 formulation, and it's updated in 2020. And they added a couple of refinements, and I can't say they're new because we've heard them before. But the first one is around compensation. We've always talked about incentives to do business ethically and in compliance. The DOJ re-emphasized that. But the one that really was a bit of a different twist was on clawbacks. Now, clawbacks have been around for a while. I'm going to point to one example where we saw them in another case, but the DOJ wants to see clawbacks on executives, or rather individuals who were involved in bribery and corruption. I have lots of questions about this. Matt Kelly, who's not here to defend himself, thinks that they may be leading towards some sort of dollar for dollar credit if a company engages in clawbacks. I'm not quite sure how that will work in the amount of fines and penalties under the U.S. sentencing guidelines or corporate enforcement policy. But to claw back, that's a civil remedy. And for a company to engage in that, they have to have a contractual right to do that. Can't claw back salary because somebody did something wrong. You have to have the contractual right to do that. And most of us don't have contracts that have that requirement in that. So I think executives in the C-suite and boards may have that. But you have to, unless the person agrees to it, you have to go to court to enforce it, or you have to go to an arbitrator to enforce it. So I don't know if a company is going to receive credit for trying to enforce clawbacks. The president of CBS fought his attempts at clawbacks, as did the CEO of McDonald's. We have seen that in one FCPA case, although it was completely unrelated to the enforcement action in Goldman Sachs. A couple of $100 million was clawed back from senior executives, including the current CEO of Goldman Sachs. Now, that money was paid back voluntarily, and it was, once again, not a part of the FCPA or greater anti-corruption settlement across the globe, but we do have that one model. Clawbacks potentially could put the fear of God in executives, and that might be another factor. But companies are going to need to look at this. They're going to have to bring in their compensation experts. They're going to have to look at the contracts, and they're going to have to put these provisions in contracts. The second part of the cooperation, well, let me just say, do we have any comments on that at this point? Karen?
I mean, I always have a comment about it, but I agree. I mean, I last rant, I think I talked about declinations with disgorgement, and the remedy of disgorgement is maybe not one that the DOJ has because of this, as you point out, the process of that. They can have a punitive, they can fines and these things, but certainly in light of a declination, that is just an NPA and called an NPA. It's an agreement, and part of the agreement is you pay us back. So this is an interesting one, especially with the third party sort of idea that your client, I mean, that, that has to be even in the contract for the executive. Fascinating. And that's governed by civil law. I mean, I think that's a fascinating take, Tom. So I don't really have a comment. I'm sort of, my mind is still thinking through all that because there's a lot there.
Mr. Marks.
I think, I'm not 100% positive, so someone's going to have to fact check me here, but from a governance perspective, back in, I don't know whether it was 2005, 6 or 7, right around that time period, but AT&T, Dell, the Gap, I recall, all instituted clawback rules in their contracts with the executives in order to improve corporate governance. And I think, from collecting some of the proxy data over the years, that many of the organizations do have some type of clawback provision in there. What they are, I'm not 100% certain, but I think it's interesting. I also think it might be interesting now, again, when I talk about organizational justice, if in fact you are disciplining folks, whether they're actually executing on the terms and conditions that they have in those contracts and agreements with those executives. So, if that might have to be a little bit more transparent today than before, just because of the things that we're talking about. But it's kind of interesting to me that some companies have them and some companies don't.
There is a second part to the information around effectiveness of corporate compliance programs, and it relates to third-party apps and personal devices and third-party apps around messaging. This seems to me that the department is very irritated with not necessarily companies, but individuals using their own private phones or phones that companies aren't aware of or aren't monitoring, and or third-party apps that don't save communications. And I think this is certainly broader than the FCPA. Banks, for instance, are paying hundreds of millions of dollars in fines for allowing this to happen during the pandemic. It is fine certainly for the DOJ to say that. The problem I have, or the issue I have rather, is that it's saying to the companies, oh, you figure it out, and you figure it out to our satisfaction. Now, the memo did say DAG Monaco has instructed the department to come up with some rules, regulations, or policies around this, and it will be inputted into an updated evaluation of corporate compliance programs. But at this point, she's put the onus on companies. And so that means if any of us are advising companies, we need to tell them, we've got to figure this out. We've got to write a protocol, and we've got to document that protocol and hope that that protocol will satisfy the department if we get in one of these situations. I think Mr. Armstrong's eyebrows are going to blow up as he thinks about the implications of GDPR around this. And that's another part of the department's memo we didn't even get into, which is privacy laws in other countries. But Jonathan, maybe I could start with you. How do you see this impacting your clients in the EU and England, and your advice you might give them?
Well, I think it truly is challenging, isn't it? You can't save data for a rainy day. You can't squirrel it away. I've talked before when we talked on this topic about, I have an oar in my loft at home, and the boat long since died that the oar belonged to. I've used that oar once in 25 years when my daughter was aged 6 and wanted to dress as a Florence, Grace Darling, a lifeboat rescue hero. And there's no justifiable reason for me to keep that or that paddle in my loft for 25 years against another fancy dress campaign coming up. And it's the same with data. We squirrel data away in our lofts, and we have no justification for it. And this is almost like a mandatory squirreling away of data. It's not going to work under GDPR. And I also question whether it's actually in anybody's interests to have mass data grabs. Obviously, I'm not talking here about a focused look at people's emails. Data is often the perpetual witness to wrongdoing. In the UK, we've had, serious cases and amusing or semi-amusing cases. The fight over Wayne Rooney's wife, for example, and cell phones that go overboard on fishing trips. We've had loads of examples of people trying to alter the data that they've got to suit themselves. I'm not talking about that. People who deliberately destroy data that's relevant to an investigation or litigation deserve consequences. But I know in 2016, I interviewed the director of the SFO at a conference, and he told me then that he had 2 petabytes of data that he'd acquired in investigations. So cases like Rolls-Royce, where part of the settlement is you give us a whole load of data and we can sweat that. So he had 2 petabytes of data. Obviously, everybody watching knows what a petabyte is, but for those who don't, that's 8 times the volume of data that the Library of Congress has acquired from 1800 to 2011. So imagine the Library of Congress in 2011, multiply it by 8, and that's the amount of data that the Serious Fraud Office had acquired in recent investigations. And so I then said to him, and what do you intend to do with it? And paraphrasing, he said, I don't know. I've got a big computer. I can't recruit the staff to run it. I can't, on government salary, hire the people to investigate that data. And he said, I'm going to look at a scheme to bring students in as part of their university degree to help me sweat the data. That isn't an answer. So the difficulty is that finding the right data in investigations is often like finding a needle in a haystack. This bit of the memo, all it does is it acquires more haystacks. And that's a difficulty for government as well as for corporations. There's a cost involved in acquiring the haystack. It might not be lawful to enlarge the haystack because of GDPR, and your chances of finding a needle in a bigger haystack are less than your chances of finding a needle in the average size haystack.
So we could probably beat this a lot longer, but in the interest of our listeners and our time, we're going to move on to our fan favorites of shout outs and rants. Frankly, I can't wait. So we're going to keep the same order. Mr. Armstrong, what do you have for us?
Well, mine's a very respectful shout out, I hope. At the time of the Queen's Jubilee, my shout out was to the late, great Queen Elizabeth II, and we mourned but celebrated her passing this week. So it's my pleasure and duty to say, long live the King, God save the King. I think King Charles has probably done the longest internship in history. He was the heir to the throne at aged 3, and he took the throne at aged 73. Obviously, he hasn't been idle in between. He did military service for 5 years in the 70s. He set up the Prince's Trust in 1976, an amazing charity. I had the privilege of working for the Prince's Trust on a voluntary basis in the 1990s. It set up, as I say, in 76. It still raises £100 million a year for good causes. I saw from my time there how active he was, sitting down with bankers and getting them to fund loans to underprivileged people trying to set up in business, and sort of eyeballing them and effectively acting as the guarantor for people from underprivileged backgrounds he'd never ever met. I'm sitting here in Cornwall at the moment, and I've seen the great work that he's done as the leader of the Duchy of Cornwall. Things like the architecture projects. Nan Sledden, for example, is 10 miles or so away from where I'm sitting today. These huge social experiments, if you like, of building new towns that are scalable and replicate the community values that we apparently had in days of yore. So what will that mean for compliance officers? Well, I think ESG is certainly, that whole area is on the new king's agenda. Will he influence legislation? Well, we don't know. Traditionally, the monarch's not influenced legislation that much, but we know that King Charles, when he was prince, had what were called the Black Spider memos, that he would handwrite notes to politicians to try and encourage direction in legislative policy. Will the Black Spider memos continue? I don't know. But will he pin his environmental heart on his sleeve still? I believe he will. So I think certainly ESG is going to be continue to be on the legislative agenda over here. And that whole thing about corporations should do good. He has used his own money, or the money allocated to him to do good, to do projects like Poundbury and Nan Sledden and some of these built environment projects. And so I think it'll be an intriguing reign. Has Charles had criticism in the past? Well, of course he has, but is it a job I would want or think I could do? No, it isn't. And he has had that 70-year internship, so it'll be really interesting to see how his thoughts develop now he's got the big seat.
Karen Woody, do you have a shout out and or rant for us?
I have done my rant already a little bit, so I'm going to move to my shout out. I also want to tip my hat to Jonathan Armstrong, because I didn't think we would get from King Charles to ESG in a matter of like 30. That was amazing. But here we are. So my shout out, I'm going to put back on my hat of Woody the film critic. So this week I watched the I think it's on HBO, HBO film Elvis, which I didn't have, necessarily high expectations of, but it is a beautiful, incredible film. And I have to say, I really appreciated seeing sort of the full nuance and detail of Elvis, who, of course, was sort of the singular person in American history, and not really as the punchline of a joke, sort of the Vegas clown scene that we see of Elvis, but to really see this impressive arc of his career, how his upbringing and sort of his childhood that was in poverty essentially meant that he interacted in a very racially diverse place, and in a way that in the 50s that might not have been happening. And so that, of course, also influenced his music. And to see, like, it's in some places maybe a bit heavy-handed, because I'm sure Elvis is not the saint that they paint him out to be all the time, but he really did do so much for the civil rights movement, and on sort of appreciating both music and culture that wasn't his own necessarily, and elevating that is really impressive to see, and really I think ties in this idea of responsibility of people in the world of celebrity, and the fact that people are watching and what that says. It is a movie that, much like watching that Titanic, you kind of are like, I know how this ends, but I don't want it to end that way. But you do know how it's going. Tom Hanks plays the villain in some ways, his manager, who ensures that he kind of keeps Elvis in a bit of a gilded cage. But I mean, really fascinating, and an insight that I don't think people, younger than really my parents have much insight into when you think of who Elvis is or was. You just think of a goofy guy in a white suit in Vegas. But so that is my shout out to that movie. I thought it was great.
Jonathan Marks.
Oh. I'm going to do a rant today. It should be no surprise. So I had the privilege of speaking last week with the illustrious, extremely talented and credentialized Mr. Tom Fox in a little town they call Houston, Texas. And I did my normal thing. I asked the question, does anyone here understand or can give me a definition of an internal control? And 51 people sat there like I had asked them for the nuclear launch codes. And I kind of go back to the fact that, I even asked for people to try to dissect it and give me a definition. Do they understand that they're interlocking activities? Do they understand that they're designed to support the policies and procedures, detailing the specific preventive, detective, deterrent, directive, corroborative actions, in order to achieve some desired objective? Nothing. I got nothing. I got zero. I literally got zero. And so, my rant is this, it's great that everybody hangs their hat and says that they want to be a fraud examiner or internal auditor or anything like that. But if you don't understand the basic blocking and tackling, that scares the living what out of me. And so this is probably the 14th or 15th time I've asked this question. And I offer a significant amount of money each time if somebody gets the answer right. And Tom, as my witness, will tell you that those 51 people stood there like I literally asked them for the nuclear launch codes for the nuclear football. And it just befuddles me to know. And by the way, I'm not picking on them. I truly am not. But I think it goes to some level of disservice to the professional organizations that these people, belong to. And, it also goes to continuing education and training, because we've gone to these such amorphous concepts about crazy things that I think it's about time that we get back to the fundamental and the basics. Because if you really break down and you're really a big fan of root cause analysis, man, the reason that people are getting in trouble these days is because their internal controls just suck. And so I'm done my rant.
So I am actually going to give a shout out, and I'm going to give a shout out to Aaron Judge. For those who may not be familiar with Mr. Judge, he plays baseball for the New York Yankees. And I'd like to read the statistics of Aaron Judge as of September 21. Number one in home runs with 60. Number one in RBIs with 128. Number one in batting average with 316. Number one in runs scored with 123. Number one in bases on balls with 93. Number one with total at bats, 372. Number one on base percentage at 419. Number one with slugging percentage of 703. Number one at OPS, 1.129. And number one at wins above replacement at 9.7. But the one I want to focus on is the home runs, because 60 is still the magic number in my head. It's what I grew up with. It's what almost everybody grew up with before the 1990s. And he's at 60, and he's a Yankee. Babe Ruth set the record with 60. It was broken by Roger Maris in 1961, which, guess what, was 61 years ago today. So we had 61 home runs in 1961. 61 years later, Aaron Judge is on the verge of breaking that record. And it's part of a supplemental shout out. I'm going to shout out to the baseball gods, because the Boston Red Sox are in the Bronx this weekend for a 3-game series. And the hate between Boston and New York is beyond legendary. And I can't think of a better platform, place, TV station, any other way for Aaron Judge to break Roger Maris's record, who broke Babe Ruth. So Aaron Judge, great year, one for the ages and for the baseball gods. Thank you for putting the Red Sox in Yankee Stadium this weekend. So, ladies and gentlemen, this has been a heck of an episode, and I can't wait to see what we come up with next time.